Hello, and welcome to our June edition of LLFtv's Landlord Advocate. I'm Robert Chesson, Managing Partner here at Landlord Law Firm, and this month we'll pick up with our third installment of the court process for summary process evictions here in Connecticut. Our third installment picks up in the post-judgment arena, after you've gotten a judgment from the courts associated with your eviction case. Because this process can really be broken into quite a number of different topics, we're going to cover two of them this month and then the last one coming up in July. First, we're going to talk about what happens if you get a default judgment. That means you got a judgment from the court without actually having to go to court because the defendant, the tenants, did not respond to the paperwork that you filed in court and you actually won the case without having to go to the courthouse. This scenario plays out in two ways. Number one, the execution or the document necessary for the marshal to actually remove someone is issued shortly after a mandatory stay by the court, and you're able to regain possession of the unit with that default judgment without any further involvement in the courthouse. The next scenario, which we see quite often, is the tenant, the defendant, actually files something in the courthouse that prevents you from using the judgment that you've already obtained and ultimately requires returning to the court to go through the court experience that we discussed in our last video. The difference in this scenario is you've already won the judgment when the tenant attempts to open the case or return to the court to ask for more time before they're evicted. And so your approach to mediation and resolution of the case will be highly influenced by the fact that you've already won a judgment. Keep that in mind when you're trying to negotiate a resolution that you would otherwise be happy with if you return to court in that scenario. The second scenario we're going to talk about is where your judgment comes from the settlement negotiations you did during mediation and entered as judgment under a stipulated agreement, something you've probably all experienced. In this scenario, what you're ultimately hoping for is that the tenant follows the provisions of that stipulated agreement, that settlement agreement, and will either leave when they've agreed to do so or be reinstated if that's what you've agreed to happen in your mediation. In the situation where they're not complying with that stipulated agreement, then you're going to have to file something to go back to court and resolve the issue. We call that an affidavit of noncompliance, and it's basically your statement claiming that the tenant has failed to comply with the agreement as written and has thus violated the court's orders. In this situation, expect to return to the courthouse in order to resolve your differences or to go before a judge, present evidence, and prove the fact that the tenant has failed to comply with the agreement that the court ordered. In this situation, the court will issue an execution, the document again needed to remove the tenant from the premises, that you'll be able to deliver to the marshal and actually regain possession through that non-compliance process. It's this situation that gives you the most impact, the most control over the outcome. You can agree to a further stipulation, or you can demand that you regain possession as soon as possible. Either way, you've got more control in this scenario than you do in others. And with that, we'll leave what happens if you go to trial for next month. Thanks for joining us here on LLFtv. Again, I'm Robert Chesson. We appreciate you watching.